Speaker. I just want to start off tonight by thanking the member from St. Albert, Edmonton, just for his heart in the cause. I think a lot of us have heard the story about Constable Wynn and the family that's been left behind by his absence, and his dear wife that sits in this place tonight listening to our debate. And it actually makes it a little bit more difficult to talk about what we talk about, because sometimes this place is filled with a lot of words. But tonight, these words are powerful words that have impacted somebody's life and impact lives in the future. I just wanted to speak about the case itself, or the S-217 itself. And it's really asking for something very simple. And I think the governing party is trying to mislead this place and making it something more complicated than it really is. And may and shall really refer to two different things. May lead evidence. That's what the full term is may lead evidence. And the term that we want to change it to is shall lead evidence, or shall present evidence. There's no aspect of that that requires proof.
No standard.
It talks about evidence, to present evidence, to demand that evidence is put before the court in these kind of cases. Now, I wanted to just talk a little bit about this individual. It's an article that was in the National Post about this person that shot Constable Wynn. And I'll go over some of the details. The details a lengthy list of 57 convictions starting in April 1999, when he was ordered jailed for 2 months for theft and break and enter. In the years that followed, when Rain wasn't serving time, he was racking up convictions at Edmonton, Calgary, and smaller communities of Evansburg and Drumheller. They were for assault, assault with a weapon, drug possession, possession of prohibited firearms. He obstructed a peace officer, escaped lawful custody, and drove while disqualified. He was also convicted for breaking and entering, theft and possession of stolen property. The Parole Board of Canada documents show Rain served 2 federal jail terms as an adult, the first 2 as a 2-year sentence for possession of stolen property, driving while disqualified, the second for 3 years on charges including escaping custody and possession of a loaded prohibited weapon. Collectively, he was sentenced to serve more than 12 years in custody, but it's not clear how much of that time he actually spent behind bars. On the day he died, now this is the criminal, he was still facing 30 charges for 4 separate offenses, including fraud, resisting a peace officer, escaping lawful custody, possessing a prohibited firearm, failing to appear in court, failing to stop for police, dangerous driving, and multiple charges of breaching bail conditions. Now, Madam Speaker, we have a government that says despite all that, and there's actually 57, somebody mentioned there was over 50 convictions. It's 57, Madam Speaker. And all we're asking, all the member from Edmonton, St. Albert, Edmonton, is asking that this be put before the court when the bail is being granted or being discussed, that the evidence of this is before that particular body. And to me, I think to look elsewhere is absolutely a breach of justice for the Canadian, for our public. To look at all those convictions, 57, Mr. Speaker, to overlook those 57 convictions, and some would, we know the opposition typically sides, we have the Victims' Bill of Rights on our side, and that's one thing that I think was one of our proudest moments of our government when I was first arrived here in 2011. The Victims' Bill of Rights is something that recognizes victims and their meaningful place in these court cases in our justice system, that the system often, it seems to just overlook. As soon as somebody's a victim, as soon as they're passed away or they're gone, they're discarded. They're not even accounted for in terms of the case. It seems like they don't matter. It feels like they don't matter. And so I know our side, and I know, we've heard the other side talk about that they care about justice.
They care
about Constable Wynn's family, and they care about, these kind of issues that happen. This is one issue of hundreds across this country where these kind of previous convictions are not taken into account in bail hearings, and they need to be. We absolutely need these cases and previous convictions brought before bail hearings so these guys and ladies remain behind bars where they should be. And I think, you know, sometimes we, you know, unless it's our next door or unless it's a personal issue where it's been a family member of ours involved in the particular case, there's a distance there. And I think what I would challenge the government side, that the government has supported this legislation before. I would challenge to put themselves in that seat up there, the wife of Constable Wynn, put yourself in that seat up there and put yourself into her place and somebody that her husband's never coming home. And I challenge the other side to do this very thing. Put yourself in that place. Yeah, through the speaker. I challenge through the speaker, put themselves into that place of the families that are left behind because somebody's out walking the streets with 57 convictions and multitudes of others. I've heard of one case, Mr. Speaker, 150 previous convictions, and this person is still walking the streets committing crimes in our country. How is that even possible? Well, it's possible because there's a clause that says may instead of shall. If we put this clause into our justice system, it says shall produce evidence or shall lead evidence of previous convictions. I think we can greatly reduce the people that are walking on the streets that really shouldn't be for our own safety. And for the members of the government side, for their safety, for their kids' safety as well. So again, I'm going to challenge this side across the way. You know, you were supportive of it. Two more of you were challenged. You voted for it before. I challenge that you vote for it again, and support our justice system in Canada. Make it a justice system again and not a legal system in this place, because there's too many stories of people getting hurt. They're not coming back. They disappear off of the record, you know, and victims often do. You know, after the funeral and after all things are said and done, there's niceties that have been said and exchanged, and the Wynns have to go back to living their lives without their patriarch and their family. And this simple wording change would help that Constable Wynn and ones like him that go out to do justice for us on a daily basis, that go out and have to deal with these types of individuals on the street. It gives them a better chance of coming home at night. And I know I see on the other side shaking of heads, and I see people, you know, smiling over there and having great conversations. But this is actually some serious legislation we're discussing tonight.
Disrespect of committee.
And for me, I would appreciate a greater amount of respect for the issue at hand, considering the member that's sitting up in our gallery, and you know, the member heckles me across the way this time. You know, I guess what I can understand, and maybe I'll go into my thoughts. And the thing that I don't understand is how can this particular member and members with him on the government side support this previously because they said they're behind the intent of what this particular the bill S-217 is. They're behind what the intent is. And yet, all of a sudden, they can be completely changed in what their intent, what this thing is supposed to do and what it doesn't do, et cetera. It doesn't plug every hole, so we're not going to do it. You know, because it doesn't fix everything in the kitchen sink, we're not behind it. How about for once?
They can't even appoint judges.
How about for once just put a word in the law that gives an RCMP even a better chance of coming home at night? Why wouldn't you even give a 1 or 2% chance better at coming home at night? You know? And he's shaking his head again across the way, but
buddies in the CDA.
I guess I don't understand that. Why wouldn't we give our legal system a better shot at keeping these guys behind bars as we should, as we're all responsible in this place to do? So I guess I would call on the opposite. I would call on the government side. I would call on other opposition members too to seriously consider Wynn's Law, as we've termed it, and the fine work that the member from St. Albert Edmonton has done on this. And most of all, I think I would, and I say this in all sincerity, you know, we get partisan in this place, but this absolutely is not a partisan issue for us. This is about a justice issue. This is about keeping dangerous people off the streets so men like Constable Wynn can come home to their wife and their kids the next day. So I just challenge this place that we all do the right thing, that we all, regardless of what our parties think of this, that we all vote and do the right thing and support Bill S-217. Thank you, Mr. Speaker.